Good evening, ladies and gentlemen, boys and girls. Welcome to this fourth episode of our Being Social program. As I have been telling you, that intent of this program is to communicate, converse with experts and renowned and well-known people in the area of their expertise and work. We will eventually also have people from the ground uh, who will have only social expertise and who will not be sung heroes. So they will be unsung heroes of the society. So I'm happy to introduce today's guest, that is Mr. Prem Malhotra. Mr. Malhotra has been a member of Indian Legal Service. Besides being in the legal service, he was also uh, the president of Prevention of Money Laundering Act Commission or Tribunal, whatever he will tell us better, and Securities and SEBI Tribunal. And also he has worked in internationally in Guyana, West Indies, and he retired as Secretary Ministry of Law. I understand he also had, in addition, charge for some time as Secretary Legislatives, and a well-meaning person of intellect, integrity, and a simple man is Mr. Malhotra. So we will talk to him, and then if there are any comments from your side, we will also ask those questions to him. So, Mr. Malhotra, welcome. Could you tell us something about yourself from your education and till your uh, arrival at the Ministry of Law?
Panchi, thank you very much for inviting me on your channel and asking me to share my thoughts and views in the field in which I have worked. You too have been a very seasoned bureaucrat, part of the civil account service, and during when you were in service, we had a very good interaction on some of the platforms. Fortunately, we were neighbors also for some time, and that was, I think, the best period of my life, which we spent together, staying in the same colony and in the adjacent house. And our children have also grown together. So I think that family bonds is also very important from my, and that's a very important part of my life also. Talking about myself, I was born in Jagadhri, which is now part of Haryana. But actually, after my birth, my parents shifted to Delhi. And for all practical purposes, I am a Delhiite. I had my education in Delhi. I did my graduation from Delhi University, had my law degree from Delhi University. But because I belong to a middle class family, my father was the only member, and we had a large family. So I think I started my service career at a very early stage. My education as well as study has gone side by side. I did my Masters of Law in Political Science. I did my Master of Law also, and held and hold a diploma in Public International Law from Delhi University. Insofar as my law degree is concerned, I was fortunate enough to be the topper of my batch in the law, as well as in the Public International Law diploma, which I did from Delhi University. The university awarded me gold medal. That is my only academic achievement, but otherwise I have been a very average student because, as I told you, my study as well as the service has gone side by side. Indian Legal Service, of course, I joined after acquiring experience in the field of law as a legal officer. I got an opportunity. I started my career, starting my service from Andaman Nicobar Administration in the Law Department of Andaman Nicobar Administration way back in 78, 79. Thereafter, I came back to Delhi and worked in various capacity, working as Assistant Registrar in the Income Tax Appellate Tribunal. Thereafter, I joined Indian Legal Service. From Indian Legal Service, I got opportunity to serve as legal experts in the government of Guyana, where I trained the officers of the government of Guyana in implementing the treaty legislation into the domestic legislation. I was there for about 2 years. And within the government of India, I think this my India Legal Service gave me very good opportunity to get exposure on various forums, including as a judicial member of the Income Tax Appellate Tribunal, as chairman of the Adjudicating Authority under the Prevention of Money Laundering Act. I also worked as a member of the Securities Appellate Tribunal in Mumbai, and during that period, I was also officiating presiding officer of it for 1.5 years, which position is generally held by a former Chief Justice of a High Court or a former Supreme Court judge. That gave me a very good exposure. And as secretary, of course, I was also ex officio member of the Law Commission of India. And during that period, we have been able to give very good reports to the government and which were implemented, more importantly, with regard to the Commercial Courts Act, as well as amendment into the Arbitration and Conciliation Act of 2015, which is considered to be landmark amendments made by the government of India to promote ADR mechanism in the country. So, and in the law ministry itself, as well as you yourself has told, I was holding both the charges as a secretary in the Department of Legal Affairs as well as secretary in the Legislative Department. I got opportunity to be associated with many legislations which were introduced during my tenure of 2013 to 2016 as law secretary. And were introduced in the Parliament. Sexual harassment, prevention of sexual harassment against women in 2013, Criminal Law Amendment Bill of 2013, Companies Act of 2013, Arbitration Act, Commercial Courts Act. I think these are some of the legislations which are important, and my involvement was there. But as you know, in Government of India, nobody can take a credit for what he has done, because it's a work which is a teamwork, and in team there are many people involved. Policy makers are involved, administrative ministry people are involved, lot of many draftsmen are involved, public consultation is there. So I think maybe I can go on and on, but all I can say is that the government gave me a very good opportunity and a very good exposure to contribute in my own humble way, whatever little bit I can contribute in the field of law.
Thank you. And your experience in the securities
Appellate
tribunal,
tribunal. Appellate
security
tribunal.
appellate tribunal, could you tell us briefly about what they do and what should be there?
You see, SEBI is a market regulator which controls the market, and you see that the market, Indian market, so far as the economy is going, the Indian market is growing, and people are making lot of investment in the market because they know that there is a regulator which is a very well established regulator and one of the most, I can say, important regulator in the economic field of the country. And the way our market is regulated by the Securities and Exchange Board of India, probably no other regulator in the country is doing. Maybe you can say that SEC of America is doing a better job, but we are no less than the SEC of America. And the best practices which we are following in the market are copied by other market regulators. And the Securities Appellate Tribunal is one which adjudicate the disputes which are coming between the regulator and the market player, be it the exchanges, be it the investor, be it the companies. And I tell you that this is one of the most important appellate tribunal in the country, because and it has been given status which is almost at par with the High Court, because the appeal against the order of the Securities Appellate Tribunal lies in the Supreme Court. So this is a tribunal of a higher pedestal, and idea is that the disputes with relating to market must be, they must be resolved within a time bound manner. And in that respect, I think the Securities Appellate Tribunal is doing a good job. We have been deciding cases in a time bound manner. Generally, it doesn't take that much delay as it normally take in other judicial processes. And credit to the people who are manning it and the kind of dispute resolution which is doing, because most of the orders passed by the Securities Appellate Tribunal are upheld by the Supreme Court also. Very few orders have been reversed. So I think this ecosystem of the market regulation is doing very well. Of course, there is always scope for improvement, which we have been seeing for the last more than a decade now.
Thank you. And about the laws itself in our country, for a long time we have been banking upon the laws made during the British time, be it IPC, CRPC, Public Debt Management Act. or any other regulations, be there, those be administrative, legal, or financial. So, what is your take on the reforms? Of course, a lot of things have happened now, including the so now the IPC has been replaced by Nyaya Sanghita, whatever is the name. You would know better. So, how has been this journey of reforms, and where do we stand now?
Pantji, legal reform is an ongoing process. And when we are talking of legal reform, it doesn't talk only of the legislation, it talks of the whole reforms in the whole legal judicial system itself, be it the legal education, be it the judiciary, be it the Advocates Act, the professionals dealing with it, and the legislations which are passed either by the state legislature or by the central government, that is the parliament. And I can say that this process has been ongoing, and we have brought many new legislations to improve the legal system of the country, including the laws for the upliftment of the social and economically weaker section of the society, the children, and the women, which need a little bit more protection as compared to other people. And therefore, and all this, for all this, the provisions are inbuilt in the constitution itself. I must say that the framer of the constitution were wise enough when they divided fundamental rights as well as directive principle of state policy. In the fundamental rights, we are talking about the political rights which were given enforceability. But in the directive principle of state policy, they are the social and economic rights of the people, and they were made non-enforceable by the constitution framer. But if you look at the developments which have taken place in our country, you will find that it is more and more the directive principle of state policies which have been implemented by the various legislations which have been passed by the parliament as well as by the state government. You know, we are a federal structure. There is a division of power between the central government, the parliament, and the state legislature. Certain subjects are assigned to the states on which state legislature make the law. Certain subjects are exclusively reserved for the central government. And any subject which is not defined anywhere, parliament gets the power to make law. Whether the laws relating to the protection of child rights, whether they relate to the women, whether OBCs, other weaker section of the society, or the economically weaker section of the society, Parliament have been making law day in, day out. Only problem is with regard to their enforceability and implementation. If you are talking about the reforms, yes, I think judiciary is also taking a positive stand, because you must have seen that the judiciary, when it interprets the constitution, it interprets the constitution in a way which protect the interest of all these sections and promote the directive principles of state policy, which are direction to the state. So I think it is an ongoing process. Reforms are taking place. New laws have been passed. You talked about the CRPC, IPC, and the Evidence Act, the three laws which were of British era and have been replaced. Let me share with you, as a student of law, I can say that no major changes have been made in the definition of the offenses. It is only with regard to the procedural aspects that the changes have been made, so that there is expeditious justice available to the people who are languishing in jail, so far as the criminal matters are concerned. And so far as the civil matters are concerned, the procedures are a little bit simplified. In that direction, certain changes have been made, and more importantly, the kind of technology which is being used in justice delivery system to give better recognition to it in the justice delivery system, so that the cases are disposed of as expeditiously as possible. These changes have been made. Otherwise, only the nomenclature has been paid, and some of the provisions of the IPC which became obsolete or have been declared unconstitutional by the courts have been done away with, and certain definitions have been changed. Barring that, the offenses remain the same. It is only with regard to the procedural aspects that the changes have been brought. And I think those changes, you will see, that will definitely bring expeditious disposal of cases in the courts in civil matters as well as in criminal matters. This is only one aspect of it. I think the other aspect, which of course I would like to share, and it is a recent example which most of our audience must have also seen. The government has proposed amendments in the Advocates Act also, to bring a little more discipline in the legal profession. Unfortunately, some of the provisions have not been properly understood by the advocates, and there are certain provisions which also need to be reviewed. What I find is it was only a consultation paper in the form of a bill, it was circulated. But the advocates were agitated, thinking that this is a bill which is likely to be introduced in the parliament. So, what the government has done, that the consultation paper itself has been withdrawn, which I think was not a correct step on the part of the government. They should have put the paper in the public domain, consider the views which are coming, and then revise the bill and bring the revised bill again for public consultation. I personally find that whenever you are going to make a new legislation, if you are following the pre-legislative consultation process and take the views expressed by the public at large, and after due consideration you introduce a bill, its acceptability to the public and its implementation become more easy as compared to once you do it without having the public consultation. So this bill was withdrawn. Of course, that was a decision taken by the government. I have nothing to say on that. But I think this kind of consultation is needed in all legislation, and probably with that direction, with that intention, government passed an executive order way back in 2014, where the government said that whenever a new bill is introduced in the parliament, there will be a pre-legislative consultation process followed, where each bill will be kept in public domain for at least 30 days. And after considering the comments of the public, the bill will be revised. And those comments will also be placed before the cabinet before cabinet takes a final decision in the matter and introduces a bill in the parliament. Unfortunately, what I find in most of the cases, this process has not been followed in a strict manner. I think the time has come when, because of you, so from the stakeholder, you always give very good comments. Because if a person sitting in the ministry feels that he knows everything, probably that will not be a correct statement. Public consultation always makes you wiser, and with that public consultation, the bill which is introduced in the parliament becomes much more effective. Take, for example, the bill of this arbitration and conciliation amendment bill, which was introduced in parliament in 2015, was after a consultation which was taking place for almost 10 years. So I don't approve that consultation should go on so long. Consultation should be completed within a limited period. But because there were certain important issues which were raised, therefore you came out with very good suggestion, and probably we find that to reduce the pendency in the courts, and more particularly for the commercial disputes, the Arbitration Act is now working in a much better way than it was originally doing. Similarly, a new law has been brought, that is the Mediation Act, which was passed by the Parliament in 2023. And under that also, idea is to reduce the burden of the court, and wherever possible, the disputes should be resolved through the alternate dispute resolution mechanism than having the normal litigation in the courts, which take much longer time.
Great. You almost gave full answer to the question I was about to ask. Basically, I was wanting to know on the expediency of justice as well as delivery of justice in time, which you have already said the kind of efforts government has made. So, of course, it will take time. There used to be stress on lok adalats. Nowadays, I don't hear much on that. Is it still functional, that kind of a mechanism for the smaller disputes?
Pantji, the pendency in the courts as on today is said to be in the range of 5.5 crore cases are pending in the courts, out of which about 45 lakh cases are pending in the high courts alone, about 70,000 cases are pending in the Supreme Court, and rest of them are in the district and subordinate courts. This is a really unfortunate situation, and in fact, talking of the period prior to COVID, the pendency used to be in the range of 3 to 3.25 crore. This has increased after the COVID. So what do you say? Whether the disposal rate has gone down, or the number of cases which have been filed has increased, or there are other reasons for it because the new laws are coming, new cases are coming. What is the reason? I don't know. But the pendency has increased. You talked about the Lok Adalat. I think this is the only platform in the country which is successfully being conducted under the guidance of Supreme Court at the central level, and in the at the high courts at the state level, and under the direction of the district courts in the district level, where large number of cases or disputes are settled through Lok Adalat. How this system of Lok Adalat work? This Lok Adalat work under the Legal Services Authority Act of 1987. It creates two kind of infrastructure. Number one, wherever the parties agreeing with regard to the pending disputes in the court, the matter is referred to the Lok Adalat for settlement. Settlement is both the parties approach the Lok Adalat. In the Lok Adalat, there is a legal person, there is a social worker, and there is a local person available. So these two or three persons sitting together, they tell the parties about the weaknesses of their case, strength of their case, and ask them for amicable settlement. When both the parties agree to that settlement, it goes back to the court, and then ultimately, as a decree of the court, it acquires a finality. So the further scope of appeal is reduced. Secondly, take for example, suppose there is a civil dispute with regard to money matter, and I have to take, say, some 1 lakh rupees from somebody, and today he is willing to settle the dispute by paying me 60,000. Which is a better option? Whether I should go and litigate for 10 years, or I should accept 60,000 today and use that money instead of 1 lakh and settle the dispute. Under Lok Adalat, this is the mechanism, this is adopted. This is one way. Second thing which has been done under the Legal Service Authorities Act is to give legal aid to those people who cannot afford their own litigation in the court. That is another important aspect which many of the people may not be knowing at the ground level. So there are legal aid cells available at district level, at the state level, at the central level, where people who are not economically well off and cannot defend their cases, they are provided the legal services for defending their cases, and Legal Service Authority provides them financial help as well as the services of a legal counsel. So I think that act is doing very well, and it is only because this act is doing very well, probably we are talking of the pendency of 5.5 crore. Otherwise, the pendency would have been much more. And secondly, Government of India is interested in promoting the ADR mechanism, that is in commercial disputes and in family disputes and other. The mechanism of mediation, conciliation, and arbitration. These are the three mechanisms, or you can call negotiation also. These are the mechanisms which are adopted as an alternate to the normal court procedures. Therefore, they are called alternate dispute resolution mechanism. Through this mechanism also, because the laws are in place, I think many disputes are going there, and probably there, so far as government is concerned, probably I would like to put a rider that many of the government officers are said to be not taking a decision at their level and forcing litigation to go to court, because of which it is said that government is the largest litigant before the courts. I think there is a catch to this. Yes, government is a largest litigant in the courts for one reason. One, of course, as I said, some of the officers, they don't take decision and they file an appeal before the next higher authority, even if there is no merit or there is a lesser merit, or the order passed by the lower courts is judicially a sound order, still they go in appeal, which increases the pendency in the higher court. That is one reason. Secondly, I always say that government will be the biggest litigant by any reason, even if you make all the good decisions, and the bureaucrats also take the right decision for the simple reason, because thousands of decisions are taken by the government functionaries every day, which no other authority takes. So government will be the largest litigant. What we need to check is the frivolous and vexatious litigation doesn't go to the court. It is only in genuine cases that the cases go to the court. And there also, if the courts start deciding cases within the timelines prescribed in the statutes, probably the pendency in the courts can also be reduced. But going by the present tendency, I remember a statement made by one of the judges in one of the public functions where he said that with the present kind of system of working of the courts, with the present strength, even if no new cases are filed in the courts, to complete to finish all the pending cases in the courts, it will take another 100 years. If that is the situation, can we say that we are in a comfortable situation? Probably we are not. So I think in all the reforms which we have done, we have been able to control certain pendency, but I think a lot still needs to be done, which we have not done. And the reforms which are coming or which are taking place under the present regime, I think they will bring some good results in the coming days.
Thank you. And as you know, now the entire world is a cyberspace. We have had cyber laws, we have had parallel activities going around in the tech driven platforms. And in spite of all these cyber laws, we have increasingly um, increasing misuse of technology for the purpose of making fraudulent activities and malicious activities, and also personally and politically misuse of social media. And we don't see any respite from all this. And now on top of it, now this new digital arrest thing is coming up. And I don't think any effective mechanism exists for this. Uh, where does it lead the digital era to us?
Pantri, I think you are raising a very, very, very important question, and I think most of our audience will also be interested in knowing what is happening in this direction. I will answer this question in two ways. Number one is the use of cyber laws or cyber security or misuse of it. That is one part, and the second of use of information and communication technology in the justice delivery system. These are, I think, two independent aspects. First, I will deal with the issue which you are raising. I think technology is moving too fast, and probably law is not in a position to keep pace with the changes in the technology. That is one aspect of it. Does it mean that the law is incompetent or insufficient to tackle all this situation? Probably by the time you make the law, probably technology has advanced too much, and probably your law is left behind. Take, for example, Information Technology Act of 2000. When it was initially passed, the only objective of the law was that electronic evidence, electronic documents, they may be taken into evidence. But there was, at that time, there was no thought that the offenses which are given by the technology users, they should also be punished. There was no such provision. That was done only by an amendment made in 2007. And even then, to deal with the technology, to deal with the crimes which are taking place, like you are talking about the digital arrest and other, I'm sorry to say that we have not been able to make good laws in that direction in spite of our best efforts. The recently we passed the uh, Personal Digital Data Protection Act, and of course there was a lot of consultation which has taken place. But principal legislation has been passed, but the rules which are to be framed there under for its proper implementation to see that there is no misuse of the digital technology. We have not been able to come out with that kind of strict rules for its enforcement. Enforcement of rules, implementation of rule is more important than the passing of the law itself. If you pass a law and if you are not able to implement it properly, I think no use making such a law. Then you can do it by executive orders also. If a law is there, properly implement it so that it is not misused. Cyber arrest, even I think Prime Minister has himself come on the TV platform where he has said there is nothing like digital arrest, but there is no awareness among the people, and people are exploited. Once I take a call which is a uh, uh, which is frightening me with consequences, and I don't know whether he is right or wrong, and I start accepting what he's saying. and start doing what he's saying, probably there is nothing to check it. And I can share with you my own experience. A person came to me because after my demitting office, I'm doing my some of legal consultancy. I'm going and delivering some lectures in some of the universities also, and meeting people in the field, and they do consult me in these areas also. One of the person, he came to me and he said that probably his this credit card has been misused. So I asked him immediately, you ask the bank to stop use of the credit card, and they should stop and all transactions on the credit card, and lodge a complaint in the police. When he went to register the FIR, they said, well, we can't register an FIR, you go to the cyber cell. And where is that cyber cell? That the police authorities were not in a position to guide the complainant where he should go and file his complaint. When he forced them to register a complaint, the complaint was registered under the IPC. At that time, of course, the original IPC was there, not the new one. And he said it's only a complaint which I'll be registering under section 420 and nothing beyond that. But if you want to register a complaint under the cyber cell, you have to go to a different department. So if the law enforcing agencies themselves are not able to guide the people properly, what to type of a common man, and they are duped by these people who are experts in committing crime. So I think the social awareness which need to be there among the common men, and educating the implementing agencies properly to ensure that they are able to enforce the law, and not asking senior citizens or others who have been duped of their hard-earned money to running them from pillar to post. If there is a central portal available and you can register a complaint there, I think that will serve the purpose. We have certain numbers. Police people say that you registered your complaints, but most of the people who approach me, they say that most of them are not able to register their complaint on the portal which has been given. And I know myself also, when I was receiving this kind of email on my email ID, that you have visited certain sites which are prohibited and action will be taken against you. You call us on such and such number. When I forwarded this kind of complaint to the cyber cell, the response I got was that this is a fake complaint. You go and register your complaint with the local police. If this kind of messages you are getting, probably the common man gets disturbed that where should I approach, and therefore the people who are committing this kind of crime, they get encouraged because they know that the complainant will be running from pillar to post, and ultimately he won't be, only few people will be able to register their complaints. All of them will not be able to do that. I think the time has come where this kind of accessibility to the common man should be much easier. Probably there should be more of advocacy and awareness so that this kind of crime can be checked. And so far as the law is concerned, I tell you, the parliament makes a law which is wide enough under which rules can be made. And probably the law enforcing agency, by making those kind of rules, can make these laws more effective, which is not happening as of now. So through this channel, I will request the law enforcing agency that in addition to doing the advocacy, they also must take quick action, and the site which they have created, whether it is an email ID or some contact number which is available, it should be easily accessible. And if a complaint is registered there, they should forward it to the concerned agency for proper investigation. They should contact the concerned person against whom the crime has been committed, so that there is a fear created in the mind of the lawbreaker that if I'm breaking the law, I will be caught sooner than later.
Thank you. 1930 is the number given by Ministry of Home Affairs for this purpose to lodge complaints. I am not sure how effective it is because I haven't used it myself.
But
You
Pansy,
have,
as I said these are available. But accessibility, because the people who approach me generally say accessibility is not as secure or as helpful as it should be.
yes, that's right. So it should be simple and reachable and
Exactly, that is the point
report.
which I'm making.
Thank you. Another aspect I certainly mentioned was the misuse of social media. You know, we all know this has been the best thing to happen, that we have social media. Communication is completely uh, open, and There have been instances where the heavyweight politicians in India, somebody wrote against them, they got punished. But social matters, nobody takes a punishment. Mahakumbh people go for a dip and make vulgar videos of women taking bath. People make edited statements of others. Now the new animal has come, artificial intelligence. They can exchange anybody's face or head to another body, and a lot of things can happen. So these are areas where I think, do you think that the government should come up with a kind of a policy or or a transparent and benevolent restriction? I'm not saying punitive kind of scenario, but there has to be some punishment. Of course, if there is a law, there has to be some punishment.
Panji, again, a very, very important question which can be debated for a long time. But of course, because of the time constraint which we have, I would just like to make few important remarks. And that important remark which I want, you cannot stop the growth of social media in the age of technology. And social media is doing service, good service to the society. That also goes without saying. You see, getting news through electronic media or even print media, I mean, it may take times, but through social media, immediately you can send your message to the whole world immediately within, but just by clicking a button, you can spend it. But simply because certain people are misusing it, I think is no ground that you should stop its growth. So far as regulation is concerned, yes, it need to be regulated. And if somebody is misusing it, there should be a law to take care of that, and that person must be told that look here, social media is for the benefit of the society to have easy access and easy connectivity to the people and to express good things in the society. If you are spreading bad things, unlawful activity or activity which are undesirable, you will be booked under the law. And it's not that as in today law doesn't exist. Law does exist. Question is of its enforceability. Many a time there is a problem. Take for example, it is my content. I'm delivering this content through social media. That is the person who is delivering it, or the mechanism which I'm using for delivery of this message to the people. The person who is delivering the content, he should also be responsible to see that he is not forwarding the content, or the mechanism is not used to spread a content which is undesirable, unlawful, or illegal. The responsibility has to be of both, of the person who is sending this kind of message and the person who is delivering it, or the mechanism which is being used for delivering this message. So law does exist. Only issue is its enforceability. If we are able to enforce it properly. Now take for example, I give you a very general example, atomic energy. Atomic energy, you can use it for making atom bomb also. You can make it for the good of the society also. Whether you want to make atom bomb or you want to use it for the good of the society. Similarly, social media. Social media, you can spread good things through the social media, which immediately reaches the common man and benefit them. And you can misuse it also. But that misuse, I mean, it's not the responsibility only of the government. As a citizens of this country, are we not supposed to act responsibly? Are the NGOs not responsible to spread awareness among the people? Social media is for your benefit, not for your misuse. Similarly, if you want my fundamental right to be protected, that okay, I want to use social media for spreading information or giving good information because it is my fundamental right. Is it not my fundamental duty that I must protect the right of the other person also, whose right will be violated in case I misuse the social media? I think these are much wider issue. But saying that it cannot be regulated will not be a correct position. Government will be fully competent to regulate it. But again, I'm saying it is not the responsibility of the government alone. It is the NGOs. It is the social people who are socially and economically well off. And the person who are using the social media, there must be a self-imposed discipline on them as to how they want to make use of the social media. I'm very happy you talked about the artificial intelligence. Same thing about artificial intelligence also. Use it for the good of the humanity, not for the for meeting your personal ends. If somebody is doing it for your personal end, law can take care of it, and it is not necessary. And as I said, the constitution is our constitution is a vibrant constitution. It is a living document. It gives enough leverage to the government to issue executive instructions, and those executive instructions can also be enforced by the law enforcing agency. Of course, probably there cannot be imprisonment or other fine that can be imposed, but I think that kind of spreading awareness through other electronic media or print media for proper use of social platform, so or social media, I think will be a good example. Thank you.
And yes, extending the artificial intelligence argument a bit further, it can be used immensely in the justice system as well to me, because as you know that in the government we use this phrase in the courts also, similarly likely placed. So one decision, if it is applicable, it should be applicable to similarly likely placed, but the people either out of ignorance or because of the long process of justice, they know that just I want to punish this guy for going to the court. They would not give them that benefit. So artificial intelligence can screen at the petition level and give judgment that this has already been decided. So please extend this benefit. So those kind of things I foresee someday in the judicial system. For now, the delivery of justice in the courts, as a common citizen, I find very cumbersome, rigid, and complicated. It is more complicated in terms of procedures, and further complications are brought in by lawyers, and the judges have their own limitation because they cannot give final judgment without knowing all the facts, and the law is blind. And I often say law is blind, but judges are not. So they should think of simplification of this process as well, particularly in the artificial intelligence era.
Pankaj, let me correct the statement that the law is blind. I think law is not blind. It is misunderstood term by the common man. But those who know the law, they only say that the law is blind. As you saw, when Justice Chandrachud was the Chief Justice, that Lady of Justice, the picture itself, the image itself has been changed. That scarf has been taken out, and the balance is also changed, and the now the Lady of Justice is wearing a sari instead of the original European dress which the Lady of Justice was wearing. So law is blind in the sense that law will be that the judges will take decision based only on the facts placed before them and the law as it stands today, and they will not be guided by other factors which are not part of the record. So in that sense, you can say that the law is blind. Law is blind because it looks only at the facts and the law based on which the decisions are to be taken. But so far as the justice delivery system is concerned, I think uh, I'll give full credit to our judiciary. That is one of the best judiciary in the world. In reply to one of your earlier question, I said that the justice delivery, I'll be talking about the use of information communication technology in two parts. One was the misuse of it, and the second was use of ICT in the justice delivery system. And probably your this question is again relatable to that. Use of artificial intelligence in the justice delivery system is relatable to that. Let me tell for the benefit of my viewers that it was as early in 2005 when Justice R.C. Lahoti was the Chief Justice. He constituted a special committee of judges in the Supreme Court itself as to how to best implement the information and communication technology in the justice delivery system. Although prior to that also, the use of technology in justice delivery had started, like filing, e-filing of the documents. Of course, so far as the hearing of the cases online is concerned, that started only during the COVID period, because prior to that, there was no such legal recognition of given. And probably judges as well as the advocates were not interested in e-hearing of the cases, virtual hearing of the cases. They wanted personal hearing, and even the kind of confidence which it should have generated among the litigants was not there. But during COVID, I mean, sometime you see some adverse situation, it come as a blessing in disguise. So far as the virtual courts are concerned, this COVID was a I can say that this was a virtue in disguise for the simple reason that the Supreme Court passed an order under Article 142 of the Constitution, which is its inherent jurisdiction, saying that the courts can hold virtual hearing because we cannot the courts cannot come to a standstill during this particular period when other services have come to a complete standstill. Therefore, this virtual hearing got recognition, and now it has been given a statutory backing also under the new law. So far as use of artificial intelligence is concerned, so far as ICT, use of ICT in the justice delivery is concerned, it has moved too far. It's, you can't say, you see, there was a time when you have to approach your advocate, by mera case kab hearing mein aayega, advocate will tell you, and he will be charging fee for even telling this thing. Now you can open the website of any high court, any district court, and you can know where your case is, at what stage it is pending, where it is lying, when it will come for hearing. And the Supreme Court, even if it is delivering a judgment running into 500 pages, the moment it is delivered, within next 1 minute, it is available on your website. You can access it, and you can see the court proceedings live on your screen. So, use of information technology and in the justice delivery system has definitely grown, and during the last 15 years, it has grown like anything. So, for the use of artificial intelligence is concerned, let me share with the viewers. It was when Justice Ramana was the Chief Justice and Justice Chandrachud was the head of the technology committee. They developed a software with the name SUPACE, SUPACE. I don't remember its exactly full term, but that is the short form. And under this, the software was developed, where on trial basis, it was thought that so far as criminal appeals are concerned, which are filed in the High Court, they will be decided by artificial intelligence. The facts will be collected by artificial intelligence, case law will be done, because all this work was being done by the researchers in the high courts. But so far as the final decision is concerned, that decision only will be taken by the judge. But rest of the work, secretarial work, which is normally done through hearing in the courts, will be done through artificial intelligence through this software known as SUPACE. This was implemented on trial basis, but unfortunately, the results have not been very appreciable for whatever reason. Maybe it needs little more development, or the software need little more updation. But I think the time is not far off when artificial intelligence will definitely help us in justice delivery system, and repetitive cases can be decided by using the technology. But I want to put a word of caution here. Law is a science, but it is not a mathematical science. Since it is not a medical science, since it is a social science, therefore application of mind is always necessary. That then you cannot say that the artificial intelligence will replace the human element, or the human angle, or the social angle which is required for justice delivery, which is not applicable in mathematical science. So yes, we can make use of artificial intelligence, we can make use of technology, but still for years to come, use of human angle, use of human intelligence will definitely play an important role. The shape may change, the justice delivery system may change, the use of technology may change, but ultimately human angle will always remain, because who has created artificial intelligence? Who has created this intelligence? Technology. It is the human mind. So human mind is always superior to that. And I'll give another example to make my point here very clear. Whenever a law is made, suppose a person has committed a theft, you make a law whereby you give a discretion to the judiciary that he can be imprisoned for a period which may extend up to, say, 3 years. So you leave it to the judge, looking at the facts and circumstances of the case. If a person has committed a theft, whether the punishment should be for 6 months, it should be for 1 month, or it should be maximum 3 years. Because it is a social science, you have to look at the background of the person, the circumstances under which he has committed theft, and there are other consequences which will follow because of this, and accordingly the judge decide what should be the punishment. So same thing happens in artificial intelligence. You can collate the data, you can collect the data, you can look into the precedents, you can look into the legal provision, you can compile it, which is being done humanly as on today and take a long time. And by using artificial intelligence, you can do it in minutes. But ultimate decision taking will remain with the judges, and ultimate arguments will remain with the advocates only. Practice may change, the system of doing practice may change, but the fact remains artificial intelligence cannot replace human intelligence in totality. You may replace it, say, by 75%, but 25% of human intelligence will still remain there. That is my understanding of use of artificial intelligence and technology in the field of law.
Sure enough, it can always be a good aid to the human beings to intelligently and efficiently deliberate upon and decide upon the cases. Very well said. Couple of observations by our viewers. Mayank Arora says the public consultations also help citizens feel a part of decision making. Sure. Professor Chandrasekhar says any effort to reduce pendency is a, or it is a lip sympathy only. Sir, what do you say on that? This was abundantly covered by Mr. Malhotra earlier, so probably you can once the recording is available in the channel, you can watch that. Dr. Uma says interesting and eye-opener conversation, particularly related to cyber crime. This is an area even people like us we do not understand much on things. So I think it's a you made very useful observations, comments, and your experiences on this. Uh, Someone says nice and interesting conversation. Yes, thank you. It has to be nice.
Thank
Now
you.
we have been discussing very serious issues. Let me take you to a lighter part. What are your hobbies, Mr. Malhotra?
Well, I think person who are in the field of law, generally, if they are involved like me, as I have been doing even after superannuating from the government and having worked with the government at the apex level, drafting laws, interpreting law, handling litigation. I think that has gone into my blood even after my retirement. Also, most of my activities are related to the field of law. As I'm a visiting professor to some of the universities in the NCR region, I'm also doing a little bit of consultancy, trying to resolve certain disputes through arbitration and mechanism. And I'm helping some of the legal aid centers in resolving the people's disputes. I think that is the one thing which I feel where I normally say. And when people come to me for advice and they want to go for litigation, I generally advise them, although I have been in the government and I'm a legal practitioner, even at the cost, like I'm reminded of before I give my own comments on this, I am reminded of Mahatma Gandhi's statement, which he has written in my experiments with truth. He has said that when he was in litigation, he normally, and I'm talking of Mahatma Gandhi, that is pre-independence era when he was in
The
South
barrister
Africa.
Mahatma
But
Gandhi.
yeah, and Mahatma Gandhi, yes, sir. And what he said was that most of the time when litigation came to me, I always asked the parties to resolve their dispute out of court, either through conciliation, mediation, or other mechanism. And in the process, I didn't lose money and not necessarily my soul. I think that is more important because ultimately you give a befitting burial to a dispute, because if parties are not litigating, they will not say, okay, if I, because in litigation only one party loses, another party wins. The party which loses, it goes to the higher court. Then it becomes unending. And there is a no win-win situation. But if it is out of court settlement, it is win-win situation for both the parties, and the litigation gets a final burial. So even after my retirement, I generally try, when parties approach me, my approach generally has been to see whether this kind of litigation can be avoided. And I generally advise the younger generation, the students of law with whom I interact, I go and participate. Your practice should be in an area where you promote alternate dispute resolution mechanism. It is alternate to the litigation, where you see that the finality is acquired in the dispute and it doesn't go to the courts. You are reducing burden on the system, you are fulfilling your constitutional goal, and you are going to have a society where litigation is reduced. We as an Indian are known as a you can say permanent litigant. It is a general impression because we always say whenever there is a dispute, even if in the mohalla there is a dispute between the neighbors, क्या कहते हैं मैं तुम्हें सुप्रीम कोर्ट तक देख लूंगा. That is the general statement which is true. So I think that mindset has to change. And I'm trying to train the younger generation in that area. When I interact with the students, I generally guide them that please ensure that you don't increase litigation, you reduce litigation so that we can live in a society which is better than the society in which we are living today.
Thank you. That's a very important social work and citizen building you are doing, because the harmony comes by reconciliation, not by litigation in the society, and people should be willing to give and take, or take and give, not just take and take or give and give scenario. Mr. Malhotra, lastly, this segment I have developed from the last episode. It's a very simple, small question. You can give answers. I call it quick reflex questions.
So I
It's
can ask
like,
no comments also if I don't want to answer the question.
yes, sure, sure, sure. No comments is two words. What works better, decentralized or centralized legal system?
No, I didn't get the question. Decentralized or centralized means? Because we have a constitutional scheme. Under the constitutional scheme, there are certain powers with the state government, central with the central. And
Yes.
I think our system under the given constitution is working very well. The subjects which have been assigned to the state governments, they are doing it very well. And wherever states need assistance, center is helping it. So the present system, as it is working on a quasi-judicial federal structure, is doing very well. And I have no complaints against with that system.
So central, more or less. So,
More or less, I think.
okay. Okay. Panch Parameshwar or family courts?
Well, I think when you are talking of Panch Parmeshwar, you are talking of the Lok Adalat kind of system, which is working very well in our country, and I think that is needed.
I'm talking about panchayats up to village level.
Up to village level, we have already experimented that. An act was passed in 2017 where Panchayati Raj Act was to be implemented, but unfortunately the law has not been successful because most of the states are not working in that direction.
Who should have the final say in appointment of justices in Supreme Court and High Court? Collegium or the government?
Well, I think again, this question can't be answered in one sentence, but I'm against the collegium system because our constitution nowhere prescribes the constitutional. It is an extra constitutional mechanism imposed by the judiciary. There should be an independent commission for appointment of judges where the judges should have the final say. That is, the majority of the people of that committee should be from the judiciary, but the executive too must have say in the appointment because appointment itself doesn't amount to interference in the judiciary.
Okay. Time bound justice or open ended?
Well, it has to be time bound. That goes without saying.
Accountability of the judges or not?
Accountability of the judiciary should be within the judiciary itself, and I have always been in favor of an independent legislation to be passed by the parliament where the judiciary itself is authorized to take action against the judges who are not following the normal code of conduct which they are supposed to follow. There has to be a law to, because as on today, it is only the impeachment process, and in our country since independence, not even a single impeachment has taken place. But if judges are misconducting, there should be a law to govern it, but that law should be administered, though passed by the parliament, should be administered by the judiciary itself.
Okay, thank you for these quick answers. I'm tempted to ask you another question which is beyond my notes. You know that in the United States, Supreme Court judges once said, "What is Constitution? Constitution is what the judges of the Supreme Court say. That is the Constitution." So, what about that inference for the Indian system?
No, I don't think I won't agree with that situation because our system, which we have adopted in India, is an entirely different system. We, the people, we are supreme. We, the people of India, have given this constitution to ourselves, and we have created the three organ of the government, and these three organ of the government derive their authority or power from the constitution which we, the framer, which we, the citizens of India, has given to ourselves. And if the government of the day, be it the executive, be it legislature, be it judiciary, is not working in accordance with the provision of the constitution, we, the people of India, have the power through the electoral process to change the government itself. So the constitution is upheld.
Very well said. And lastly, this is more of a self promotion. What do you think about talk show like mine, this being social?
Well, Udayji, I know you for a long time. I think you are doing a very good service to the society. And I'll be very happy if you bring people from various fields for the purpose of educating the common man. Because during my talk, also, I talk about the awareness and advocacy of such social issues. And if those social issues, views of the people who have really contributed to the system or worked with the system and done something, if their views can be known to the common man, probably our society can become a better society to live in.
Mr. Malhotra, thank you very much for coming over and sparing our time. We are expecting this to last for about 40 minutes, but we are already 1 hour, we are done. So thank you very much and wish you all the best.
Thank you very much. Thank you very much for giving me this opportunity to share my thoughts on the important issue, more particularly which relates to my own personal experience. Thank you very much.
Thank you, viewers. Don't forget to watch the recording if you miss some parts and share with your colleagues, connections, and your groups. Mr. Murata, you do the same, please. Thank you. Good night.
Thank you.